This episode is brought to you by Lawyer Up, 7-step guide to help you find the right attorney for your needs. Legal issues can be scary, but do you know how to choose an attorney when you need one? Most people don't. I didn't. I chose the wrong attorney and I lost my case. Don't let what happened to me happen to you. Get the book Lawyer Up, and it will guide you step by step on how to intelligently choose the right attorney for any of your legal needs. Get Lawyer Up for only 99 cents today, and when you forward your receipt to us, we will send you 3 exclusive bonuses. Get Lawyer Up for only 99 cents plus your exclusive bonuses by going to www.lawyerupbook.com. That's www.lawyerupbook.com. If you're watching this episode, simply click on the link below this video.
Welcome to the Legal Advice in Paradise podcast, brought to you by www.legaladviceinparadise.com. Even in one of the most beautiful places in the world, life can be litigious. On this podcast, the best and brightest legal minds gather to help you navigate your way through every legal question you may face. This program will help you know your rights, know what steps to take, and help you find the best legal representation, all in simple, easy to understand terms. And now, here's your host, Justine Gronwald.
Aloha, Agents of Change. This is Justine Gronwald with another episode of Legal Advice in Paradise. Thank you so much for joining us again. And today it is my special honor and privilege to have Sergio Rufo today.
Good morning.
Good morning. Before we start, though, I just want to remind you that the book Lawyer Up, depending on when you're watching this, is going to be available to the Agents of Change for 99 cents on the Kindle. So what Lawyer Up is going to be about is basically based on this podcast show, and we'll teach you how to look for an attorney intelligently and tell you a little bit about my story of how I started all of this. And I have the honor of having Mr. Peter Carlisle as the person writing the foreword. So if you want to get this copy for 99 cents on the Kindle coming up, just give your name and your email by calling or texting area code 808-670-3400, and you'll be sent the link. And also, you'll be getting our podcast interviews automatically as they come out. So without any further ado, I want to introduce you to Mr. Sergio Rufo. And tell us a little bit about yourself.
Well, thank you first for having me on your podcast and your YouTube video. Nice to meet you recently, and I'm excited about your project. I'm excited for you, and I hope it does really well. As far as me, I'm not quite as interesting as you are. I'm a lawyer, so that kind of makes me uninteresting. But I was born in Windsor, Ontario, which is also known as South Detroit.
Now, I watched another podcast interview you did, and I was wondering why you refer to it as South Detroit if it's in Ontario, Canada.
Because there really is no South Detroit. It's like Honolulu is on the water and goes east and west along the water. So is Detroit is the same way, and Windsor goes underneath Detroit. So geographically, Canada is south of Detroit. That part of Canada is south of Detroit.
I see.
And one of my favorite songs is "Don't Stop Believin'" by Journey.
Oh,
so
yeah,
that's
I
how
love
we get
Journey.
the South Detroit reference.
Okay, so you're originally from Canada, but according to your interview last time with Marco, you mentioned that your family is from Italy.
Yes, my parents moved from Italy when they were in their 20s. I was born in Canada. This is all at the late 60s they moved, and they had blue-collar work, and in Canada the college is not as expensive as in the United States, so I managed to pay my way through school and make enough to, with some loans, get an American law degree as well, because Windsor and Detroit are so close to each other. You cross a bridge, and I went to 2 schools, and I have 2 law degrees.
Wow, okay.
And decided to come to warmer shores.
So your law degree is in different areas. Which are they?
You don't specialize in law school. I have a Canadian law degree and an American law degree.
Okay.
They're very similar.
Okay.
Canada, I think, sticks to the English system a little more closely than the American system does. And so there's differences, but fundamentally, the substantive law is all the same.
Okay, well, you're my first guest who is not, has more than a law degree from America.
I don't know if
you're
that's
the
a good
first.
thing. It'll come in handy if I ever want to work in Canada. Or it also allowed me to go to school in the Caribbean, so I'm qualified to practice in a lot of Caribbean countries.
Yeah, that's interesting. Interesting. Well, today we're going to talk about medical malpractice, and I know in an earlier episode we did interview Jeff Portnoy of Cage Shuddy about medical malpractice, and he made it very clear that, you know, he actually represents the doctors and the hospitals. Well, Sergio here represents the plaintiff. Now, explain to us, Sergio, what a plaintiff is.
A plaintiff is initially a person is called a claimant.
Okay.
And by the nature of the word, you have a claim against a hospital or a doctor, which I've represented doctors and hospitals for a long time, and now I'm on the claimant's side. So I guess initially you feel you have a claim, you get that claim evaluated, and you become the claimant in the first step of the process, which is an inquiry before the Medical Inquiry Conciliation Panel, or MICP for short.
I learned about that, and I had, you know, I think the everyday person doesn't know that that's preliminary. You need to do that first, right?
It is a
MICP, right?
mandatory necessary step. It used to be an MCCP, more like a little arbitration, but they've changed it about a year and a half ago to where it's more of a mediation now. If you just Google MICP or Medical Inquiry Conciliation Panel, there's a nice pamphlet that they have online. Has a lot of questions and answers just for the general public. And anybody, the claimant, you don't need to have a lawyer to file an MICP claim. It's recommended, of course. You get a lawyer to evaluate your claim, and sometimes you have a good claim, but it's not worth a lot of money, and it'll cost $20,000 to $50,000 to $100,000 just to get to trial, and you might win $50,000. So you did all that work for nothing almost, just to get your costs back.
I think that's one important thing for people to know out there, because, you know, you never know if you're going to come across these things. That's the theme of my show, is that, you know, it's not a matter of if, but, you know, when you may need legal representation. But when you get to that point, how do you know if you have a valid claim or case? But at the same time, how do we know it's worth pursuing? I think that's one of the things that people need to kind of figure out right from the beginning.
It's an important part of the evaluation, because the jury, the judge, the panel, no one can change the way you are. If you have if you lost a finger because of a bad surgery, they can't give you a finger back. All they can do is give you money. So everything boils down to money. So in evaluating your case, how much is the case worth? What have other cases settled for? Or what kind of verdicts have been received in other similar cases? What are your damages? And how much will it cost to get to a point where this case will either settle or go to trial? I just turned down a case this morning, but the case was solid. Definitely the physician made a mistake, and she did suffer damages. She had to have a second surgery, but she's okay now. And a year went by, so we tried to figure out, okay, how much are your damages? Well, this cost this and this cost that, and I had to fly here and there. So we had a ballpark figure, and I explained to her, I said, well, unless you have the money to prosecute this case, either pay the costs or pay the cost in the attorney's fees. On the contingency side, it'll be hard for you to find a firm, maybe a large firm that can roll the dice on these types of cases, and they can afford to lose their investment. But most firms will be very conservative and say your case is worth $10,000, but it's going to cost $9,000 to get it ready for trial. And those $9,000 have to be repaid to the lawyer. And then you're looking at $1,000 to split between you and the lawyer.
And it takes a while for these things. You in my case, you know, it lasted about 4 years. So that's 4 years of your life, or however long it takes. And these things just don't happen overnight. And it's in your head, you know, every waking moment when you go through these things. So that's what people need to take into consideration when they're going to go ahead with these types of things. Also, I read here that you have, you know, handled several multi-million-dollar medical malpractice claims. So you're very versed in this. Now, that would that be with the doctors, with the claimants, or a combination of both those?
With both of them. When you get in a case, it really doesn't matter a whole lot what side you're on, because the mechanics of the case are the same. You have to discover from the other side, get all their facts, take depositions, which are interviews usually in a conference room, of the other side's witnesses with their lawyer present. So you're taking their trial testimony before trial, so you know what they're going to say at trial. That's part of the discovery process.
Right.
Each side does that, and of course, one side is saying there was negligence, or there was causation of damages, and the other side is going to say the opposite. So the meat of the case is the same regardless of what side you're on. You have to be able to understand a little medicine. You have to be able to ask the right questions to make sure you know exactly what they're going to say at trial.
It's preparing yourself.
It's all about preparation.
Yeah.
All about preparation.
And then also the statutes are 2 years, right?
That's the statute of limitations, 2 years from the date of the injury. There's a wrinkle that, let's say you have surgery and they leave a sponge in there.
Ooh.
Which has happened more often than not. Maybe not a big sponge or a utensil. We had a screwdriver case. Right, we had a screwdriver case.
I'm trying to imagine that in my head right now, like in your body has a screwdriver and a sponge.
Yes, maybe not both, but
I mean,
even
you know,
one of those things.
Okay.
You might not know that. You might just think, okay, this is post-surgery pain because of the scar. A few weeks goes by, you start to get used to the pain, or it might not be any pain for 6 months, and all of a sudden you have a violent reaction, an infection or something, and they'd run some tests and they see that in there.
Right.
Now, that arguably the statute would start to run from when you knew or should have known that there was a problem. If you had no reason to know, then there's no reason it should start on the day of the surgery. So you get an extra 6 months or so.
Okay, that's what my question was going to be. You know, so you're going about life after post-surgery, and say 6 months goes by, and then you, like you said, you start feeling something. So it doesn't start the day when the surgery was done. It starts 6 months after you discovered, you know, something's wrong. That's that when it starts?
It's fair, except if you should have known something was wrong 3 months earlier. Like if you had shooting pain after 3 months, but you waited 3 more months, the other side could argue that you should have acted after 3 months and not after 6.
Wow, so these are the things like, so you have to be really alert, listen to your body, and go to your doctor. Is that what you would recommend?
That's what I'd recommend. And even if you find it within the first 6 months, don't think that you have 2 years. It's best to go like 18 months further would be the 2 year mark. So safest route is file within 2 years.
Okay. So for instance, like that case that you just turned down, when people call you, what are the typical questions that you ask them? I mean, they're pretty obvious, but you know, everyday people, they don't know if, you know, people don't know if they're going to go through any of this. So when someone calls you or, you know, inquiring, typically what do you ask them?
Well, people, they're influenced by television and movies. They think they can get justice right away.
I think that's the part. That's the part. It just doesn't happen right away.
I mean, you could solve a double murder in a 1 hour episode of Law and Order, but you cannot get a medical malpractice award in a matter of days or weeks or months. It takes years. Generally, when people call, they have a story to tell. Sometimes they just want somebody to listen. So, you know, initial questions: how did you hear about my firm? How old are you? Do you have any medical records? What part of your body is involved here? When was the surgery? Who did it? Try and look for conflicts and things like that. And then after you've asked enough questions, then you let them tell you your story. But you say, I'm going to interrupt you along the way, because sometimes they'll keep you on the phone for an hour. And that's fine. Like I said, some people just need to vent a little bit. Some people are misinformed by the media or by their friends or Rarely is it other lawyers misinforming them.
Yeah, I think that's the norm. You know, people are just absorb what's out there, like you said, media, TV, and there's a drama behind it, and like this vindication that needs to happen now, when really that's not the reality of these things.
Oh, far from it.
Yeah.
This doctor should lose his license. It's not going to happen.
Right.
Generally, what I tell people is if you've had a procedure, you think something's wrong, or you think you were mismanaged, start to write everything down. Go to Long's and buy a journal.
Okay,
write
good.
everything down. Even if you'd had to take 2 Tylenol, write it down. Write down your pain levels. Today, my arm is painful at a level of 8 out of 10. And the next day it might just be 6, and the day after that it might be 10. So start a journal. Keep all your medical receipts, even for aspirin and over-the-counter things. Start to gather your medical records, because an attorney will want to see your records. The patient's going to say one thing, oh, we never talked about this side effect. And the doctor's going to say, of course we told them about that side effect. There. And it's not always in the chart. I mean, there's different sayings. If it's not in the chart, it didn't happen. Well, yes and no. The chart is not a happening. The chart is a recording of a happening. If you said something important, you should chart it. So all these little axioms, these little rules of thumb, they don't always apply. But if it's not in the chart, you have to figure out, well, did it really happen?
Yeah, let me ask you this. I think people are being told to really take charge of their health care, right? So would it be unusual if people start going to their doctors and having a journal in hand and just writing notes down? Because I know sometimes for me, when I'm in there, I want to remember what he's recommended to me, but because it's just a conversation, it's in our busy schedules, it's easy to forget what he's recommended. I mean, would it be unusual to start doing that?
I don't see an issue with it. The doctor might ask, why are you taking notes?
That's what I was wondering.
You could say, because I'm not going to remember this. I want to know what we talked about. You're taking notes. Why can't I take notes?
Exactly. Okay.
Whether those will be admissible later at trial are a different issue. But they just help you with your recollection. And at trial or at an arbitration or proceeding, you'll have to tell a story from day 1 or even day 0 through the day you're at trial. And those notes will help you refresh your recollection if they were taken at or near the time that the event in the notes happened.
I'm in the habit, in everything that I do, I take the date and the time and little nuances too, because I do live a really busy schedule, and so it helps to go back. When I had my own trial, in deposition, I gave my attorney boatloads of my diary of what I did at work, and it's not medical malpractice, but just as a practice in itself, it brought back a lot of stuff, helped me to remember.
It's always a good idea to write things down, and you're entitled to a copy of your medical records. You might have to pay a small fee, but a lawyer will either have you bring in the records or have you sign a release to obtain the records, and then she or he will evaluate the records and probably bounce it off some of her or his medical colleagues, legal colleagues. To bring a claim before the MICP, you have to consult an expert in the same or similar field. You don't need a report or testimony from that person necessarily, but you have to sign an affidavit that you consulted with the medical expert.
I see.
And they support your case. And if you go to trial, then you'll need a live body, so to speak, either testifying, a written report. And that's really where the costs go through the roof. These physician experts will charge $500 to $1,500 an hour.
Wow.
And they'll work at least 20 hours on a case. So that's $30,000 on the high end. If they have to come out to testify in Hawaii, they'll charge you from the moment they leave their office in wherever they are, Los Angeles or Philadelphia. Pay for their hotel, their meals. I mean, a lot of them are reasonable and cut fees where they can, but it still adds up.
So let's take it from when somebody gives you a call, like the one you turned down this morning, but say you saw a potential in it, the next step would be MICP?
Well, the first step would be sending the records over.
Okay.
lawyers operate in different ways. Some lawyers just want to sign the client up, and if you're taking the matter on a contingency basis, the rules of professional conduct which govern what attorneys do say that a contingency agreement has to be in writing. Mm-hmm. You can't just say, you know, if we win, we'll split it 50-50
Mm-hmm.
or 70-30.
Mm-hmm.
It has to be in writing. So,
and a contingency means, for
contingency,
those who don't know.
Yes, thank you. You see these guys on TV, no fee unless you win, no fee unless if there's no recovery.
Mm-hmm.
Contingent means it's contingent on the outcome. If the lawyer or the firm puts in $50,000 or $100,000 in costs and they go to trial and they lose, the client doesn't pay anything, not the costs, doesn't get anything, doesn't receive anything, but doesn't pay anything either. If there is a recovery, and this is why the agreement in writing has to be specific at the beginning, there is a recovery of, say, $100,000. Then you go to the contract and see how it's split up. Most of the time, if you go through a trial, the fee will be higher. So 40% goes to the lawyer off the top plus GET. So that's $45,000 almost. And then if the lawyer put in $20,000,
that goes to him
that
too,
goes back
on
to
top.
the firm. So that's $65,000 to the firm, and the client gets $35,000, even though the contingency agreement says 60-40 for the client. So contingency means there's no money out of the client's pocket
Up front.
Sometimes you can do combinations, and I have some of these cases where the client is paying the costs, not paying the firm. The firm gets paid if there's a recovery. If there's no recovery, the firm does not get paid. So you can, most firms are flexible in the way they do things. My firm is. I have a couple of those where the client pays the cost, they get a bigger percentage at the end.
I see.
If the firm advances the cost, then it's reasonable that the firm should get a bigger percentage at the end.
So that's when, too, you have to really see if it's all worth everyone's time, right?
Right. The lawyer might be willing to put in the time. The client always at the beginning, oh, sure, I'll do whatever it takes. But then you explain to them, this could take 6 years. And then it can be an appeal, which will take 2 more years. We have to try it again, which will take 4 more years. So we can be going for 10 years. Oh, I'm in the military, I'll be gone by then. Well, not that military people shouldn't file claims, but it's just something you have to consider. Where will you be in 3, 5, 7 years? Will you be in Hawaii? Will you be in Europe? Those types of questions. And then if the defense side knows that, oh, you're being deployed to Japan, you can't even prosecute this case. There's a way to get it stayed where you won't be punished for not prosecuting it by the courts, but those are all factors that need to be considered at the beginning. So advice I would say to people who think they have a claim: step 1, get a journal, start writing everything down. Step 2, get your medical records in order, and then get a lawyer to review those records. Most firms will give free consultation. They'll look at the records. The lawyers will either say, we have a conflict, we can't take your case, or you have a case but we can't do it, or looks like you have a case, we're not in a position to front the cost. Can you pay the cost? Maybe we can come up with some hybrid type agreement. Or, you know, we're not interested in your case, here's some other names. They should tell you when your statute of limitations is. They should give you the lawyer referral service line, 537-9140. Then if they take your case again, the agreement has to be in writing. They should explain to you that it's going to take a long time. You know, a lot of people say, oh, these doctors settle quick because the insurance companies don't want to carry this from year to year. You hear that at the end of the year, like now, so November. It's like, oh, let's file a claim and we'll have some money by Christmas. It's just not going to happen that way. It's what insurance companies do is defend claims. So they don't really care if they have 10 open at the end of the year or 20 open at the end of the year. They don't look in those short time frames.
Wow, that's an eye-opener as far as, you know, people really thinking about this before they move ahead. And as I mentioned to Jeff, you know, it's a very emotional thing for people because, you know, surgery sometimes can be traumatic if it's surgery, let alone a screwdriver stuck inside. But, you know, it's people's bodies. It's very sensitive to them. This is their, you know, their life. So trying to determine whether or not to move forward, do you help people with that as gently as possible, like the one that you turned away? I mean, how's it?
I try to be compassionate on the phone,
Yeah.
or in person, and explain to them, okay, this is the process.
Yeah.
The MICP is something claimants can do themselves. If a lawyer doesn't, if they can't find a lawyer that's able to take their case, and if they can't pay the costs, they might have maybe $1,000, but they don't have $20,000 to put into this. You know? A claimant can read up on the MICP, file a claim with the MICP, pay the filing fee, which is I think $450, pay for the records to be submitted. You're allowed to submit a statement with your records, so photocopies don't cost that much for this type of proceeding. Then the proceeding itself, you have the lawyer as a chairperson and a doctor, and those two people will charge $450 an hour.
Okay, so to file to begin is $450,
Right.
and the MICP, the attorney and the medical professional are charging $450 each.
Right, and it's usually a 2
Among
to 3
themselves?
hour procedure process, and those fees are split. So let's say it's 4 hours at $900 an hour. It's $3,600 split between the two parties.
Plus the $450
Plus
to
the $450 and the
file.
plaintiff. So
So
you're
now
looking
where
at
are we at now? We're at almost
18,
5.
right? 18. Well, the 36 is split.
Oh, split between the two.
Right. So you'd pay 18 as a claimant, plus the $450 filing fee, plus whatever it costs you to make photocopies and process the thing. So $2,500 is conservative estimate.
Is the minimum, and that's just the beginning.
You won't get a decision from that.
Yeah.
You'll go to you'll be in a conference room, likely at the DCC offices, which are the old, not the old courthouse, but the current post office downtown on Merchant Street. Really nice
Department
building.
of Consumer.
Exactly.
Yeah.
Commerce and Consumer Affairs.
Yeah.
They won't issue a decision either way. Doctor, you were negligent, or claimant, you don't have a case. They'll try and get the parties to resolve it. They'll try and say, there is something there, but this is a known risk, or it really looks like there's something there. You should give this person some money, and just, let's all walk away happy.
So it's like a mediation from the very beginning.
It is. It's kind of a sit down at the beginning to try and not scare, but impress upon people that it's a long process and it's costly for both sides. And if you can settle it now, even though you might get more later, but you could also get zero later. So it's a process designed to kind of let's see if we can work it out. An initial mediation session.
So say it goes beyond that, and it looks like a good case, and that's where the attorney steps in. Someone like you would step in after that.
I would recommend that if you go to the MICP by yourself, pro se means by yourself or on behalf of yourself, you really should get an attorney before going to court. Medical malpractice cases are like Jeff said, they're not auto accident cases. Not that auto accident cases can't be complex, but they're not simple slip and falls or dog bite cases. You need to have certain experts. Certain evidence won't get in unless you have an expert to back it up. So that's when you need to you should consult an attorney at the beginning, and if the attorney says, I can't take your case, but you can go to the MICP if you want to by yourself, then you evaluate whether, again, it's a good business decision for you to spend those couple $1,000s. And sometimes that gives you the person peace of mind. They get to be in the same room with the doctor, usually. And they can't really. It used to be that you used to be able to tell your side of the case, and they used to tell their side of the case. There used to be some questioning, kind of like an arbitration. That doesn't happen anymore. They changed the law, and so you won't be able to confront the doctor in a confrontational setting. It's really a mediation setting. A conciliatory means to kind of counsel each other and console.
I imagine it's an emotional thing.
It is, but sometimes a claimant, they're willing to spend those few thousand just to have that couple hours in the same room, tell their story to some neutral people, have those people say, you know what, you do have a valid claim. Let's see if they'll give you some money. And sometimes the insurance, somebody says, okay, we'll give you a little bit of money, or we're not giving you any money. That claimant still might say, you know what, I gave it a shot, and I'm done. I don't want to go through this.
And it's just one day.
Right, but that day might take 6 months. If you were to file something today, you might get a hearing 6 months from now. So sometimes that's all claimants need. A lot of times, at the start, they always want more.
Yeah.
I want this guy's or this lady's license revoked. I want, $1 million so I can buy a boat and a car.
Well, I did hear that a lot of doctors, not too many are going into practice. One of them is the cost to do business, and it's because of malpractice insurance. Do you know anything about that? What the medical profession has to, shore up for med-mal claims and stuff like that. Is that
that
a reality?
Is accurate. There's been a lot of articles written on that, especially in the obstetrics field. I do a lot of those birth injury type cases.
I saw your website, and it talked about birth injuries, and those that's medical malpractice.
It can be, and those are complex cases that take a lot of time and money to develop. The last one I was involved in took almost exactly 9 years from when the baby was born.
That's a long
It's a long
road.
time, and the child's 9 years old, and it's needed services the whole time. So the family's strapped for cash for 9 years. There's articles. There's a lot of stuff written on that, and some of those physicians that do labor and delivery. I mean, one article I read years ago sticks in my mind. It's like the doctor said, when I'm talking to a patient, usually a woman, because pre-delivery, obviously, but even if the husband or the father's in the room, when I'm talking to a patient, behind them, I see their lawyer hovering, right? So, because I don't want to screw up because they're going to sue me.
Right.
On the flip side of that, there are a lot of bad results. Birth is a miracle. A healthy birth is like a double miracle, and a lot of things can go wrong through nobody's fault, and most of the time it is no one's fault. Sometimes it's genetics, sometimes everybody does their best and there's still a problem and an issue. But sometimes there was some neglect, some miscommunication that shouldn't happen, some overwork of the unit, overstressed. They don't have enough staff in there. Why don't they call in more people? There's been cutbacks. Hospital decisions affect the care on the floor. Sometimes it's just poor medicine being practiced, bad decisions being made in the critical moments. So those cases are very interesting, very time-consuming, very expensive, very stressful on the family and everyone involved.
So I think the big takeaway from all of this is when it comes to medical malpractice, first of all, you need to, find out, obviously, but at the same time realize, is it going to be, worth the time, and it's going to be with you for a long, long time to get resolved. And we don't want to just ignore, what you might be going through, but sometimes you got to weigh these things. And when I interviewed Susan Ichinose, we talked about something similar when it came to employee-employer type of things. Is it worth going through all of that? And so I think this is very educational for the everyday person as they're going about their day, and then something happens, and in the medical side, this is good for them to know, Because most, like you said, people go by TV and movies and, all that stuff. Yeah,
reality is often very different from TV. But I guess the 3 tips in wrapping this up would be write everything down.
Okay.
Get your medical records, and then talk to a lawyer who'll talk to you for free. 852 RUFO. There's a handful of other good guys in town. Jeff does defense work.
Yeah,
he's been doing it longer than I've been alive. But
Yeah.
He's a good guy.
He's a good guy.
And if you call him, he'll refer you to one of the top guys in the state.
All right. Well, thank you, Sergio.
Thank you very much.
That was very informative. And for those of you who want to join the Agents of Change, just go ahead and text and call with your name and email to area code 808-670-3400 and never miss an episode. So at the end of each episode for the video, we like to shaka out.
Right.
And for the audio, we say aloha and a hui ho.
Aloha.
This episode is brought to you by Lawyer Up, 7-step guide to help you find the right attorney for your needs. Legal issues can be scary, but do you know how to choose an attorney when you need one? Most people don't. I didn't. I chose the wrong attorney and I lost my case. Don't let what happened to me happen to you. Get the book Lawyer Up and it will guide you step by step on how to intelligently choose the right attorney for any of your legal needs. Get Lawyer Up for only 99 cents today, and when you forward your receipt to us, we will send you 3 exclusive bonuses. Get Lawyer Up for only 99 cents plus your exclusive bonuses by going to www.lawyerupbook.com. That's www.lawyerupbook.com. If you're watching this episode, simply click on the link below this video.